Senator Roberts.
Thank you, Chair, and thank you, Ms Dawkins, for appearing today, and thank you for your submission. I have a few questions. You talk about transparency, and I certainly echo your comments and support them. What about page algorithms? Should they be disclosed so we understand why some of us are being censored by search engines and also by distribution of our material on big tech platforms?
Senator, can you just repeat what you said? Page algorithms, was it?
Yeah, the algorithms that determine who will see a page. If we post something on Facebook or Instagram, Twitter, who will see it, who won't see it? Because we know we're being very, very heavily banned on Facebook, for example. And YouTube has taken off 39 of my videos in the last 12 months that were up there for as long as 12 months ago. So they're already censoring.
Understood, Senator. So this is data that we would love to see more of from big tech. It's data that does exist under the EU's transparency framework, so you can request and see, in some cases in a public fashion, precisely what the top-line trends are for platform activity on, as you say, shadow banning, and for the enforcement or perhaps over-enforcement of their policies. So I think there's certainly an issue where these decisions are getting made in the dark. And the more that there's an openness to the public from big tech that has to get created through legislation, because we're not seeing it voluntarily, the more that we see the numbers on what they're doing and who it's being applied to, and the more that researchers can test that and see if there is unevenness or if there is preferential treatment being applied across the spectrum, I do think that public trust will improve online. But I will reiterate my point at the risk of sounding like a broken record. This is why data access is so important, Senator.
Thank you so much. The next thing comes to the fact that this bill uses the platforms to self-censor. And what it does, I think very, very cunning, in a cunning way, is that for under-censoring, a platform will pay a huge penalty, 30% of global revenue, something like that, I think, from memory. For over-censoring, there's no penalty. So the risk is in under-censoring, and because there's no penalty on over-censoring, it will drive platforms to over-censor just to protect themselves and their revenue. Can you make a comment on that?
I think that it's not as high as 30%. I think it was a single-digit number, Senator. I don't have it in front of me.
I might be wrong.
I think what you're talking about is the risk of over-enforcement of platform policies, and if it is helpful in any way to alleviate concerns, our testing is routinely that under-enforcement is the norm. We always get about a single-digit percentage of enforcement of genuine policy breaches on platforms. It's usually sitting around 6 or 7%. I'm happy to table a report that we wrote last year in the context of the referendum, where we went out and tested whether platforms over-enforce or under-enforce the moderation of political content. And we did find that the numbers are extremely low on the enforcement side.
Thank you, Ms Dawkins. That's the situation now. Once this bill comes in, if it comes in, there's a lot of pressure in the public to not bring it in. If it comes in, then there'll be an incentive to over-censor and a disincentive to under-censor.
I agree that it's hard to speculate on the future, but I suppose looking at path dependency, where I probably wouldn't use the word censor, I'd use the word applying the platform policies, whatever they may be. This is a bill that works off the platform policies, so it's whatever rules that they have that they're choosing to apply. I understand that the bill is seeking an enforcement of whatever those rules are. So we do have to go back to the primary documents, and platform policies are extremely conservative in how they define their breaches and how they enforce them. So this is an issue that does cut both ways.
Thank you. What about an arbiter of truth and an arbiter of harm? The bill, as I understand it, does not specify who determines the harm and the extent of harm, and who determines what the truth is.
It's worth looking into how the mis and disinformation issue has been regulated already on platforms. And I'm certainly not saying it's perfect. We've got issues with it for a range of reasons. But there's the role of fact-checking, which is usually the arbiter of fact in that there are referrals made to verified third-party fact-checkers, and those fact-checkers will determine the veracity of that statement, and then platforms will act on that fact check. There's two issues with that, of course. The fact-checking ecosystem in Australia is small and it's also quite brittle. We did see issues with fact-checking last year, and I understand that's a public trust issue. The second point I'll make is when fact-checkers do make a finding, how platforms respond to that fact-check is in doubt. So those are the points that I would make on the arbiter of truth, Senator.
And Senator Roberts, thank you very much.